International Crime Agency and others. Part A.
Perry. Thank you very much, my lady. May it please the court. I hope to be able to assist the court this morning by making submissions in relation to the key issue of whether the NCA treated the identification of specific criminal property as a precondition to any investigative step.
Sorry, Mr. Perry, you're dropping your voice.
I'm sorry, my lord. I'm going to be making submissions in relation to the key point in relation to whether there was a cart before the horse. So I'm going to do that. I'm going to say the NCA did no such thing, and the judge found that they had done no such thing. I'll come on to analyse it as we look at some of the materials. I'm going to start with some context, because there is a context to the case, inevitably, which gives it some important background detail. It's a highly unusual case in many ways, and the correspondence, which I'm going to turn to, I hope very economically, shows how unusual it is. And I will be turning to the correspondence in order to make this point, that one of the arguments being advanced to the various public authorities, not just the NCA, but also HMRC, Secretary of State, was that criminal offences were actually taking place under their noses, and that was apparent from a sort of statistical analysis of the amount of tainted cotton that came out of China. So, in other words, what the claimants were saying in correspondence was, you should be applying this assumption. And that's how it started off. So I'm going to be looking at that because it puts some of the arguments and some of the correspondence in context. But just before I come on to do that, may I first of all, please, just make some factual observations which will frame some of the other submissions that I will be making. The first point is, if there was any criminal property in this case, it must arise as a result of criminal offending in China. So that would be the starting point so that would be the source of the criminal property. And the offences would be in relation to the production of cotton somewhere in Xinjiang, but it's unclear precisely where. And the criminal property would be in the form of cotton being produced in Xinjiang as a result of those offences. But there were certain complications that take this case out of the usual. And the complications were, first of all, cotton is also being produced that's not tainted.
Sorry, you talk about the offences would be in relation to the production of the cotton. If I can put it this way, underlying offences.
Yes.
Offence, use, possession, acquisition.
Would be
here.
Yes.
Yes.
But
good, I understand.
Yes.
Thank you.
Sorry, lady.
No, I
yes.
understand.
But the criminal property has to be, there has to be a predicate offence, and
exactly.
that's the predicate
Yes,
offence.
understood.
But the complicating factors were cotton is also being produced in Xinjiang that's not tainted by criminality. And cotton is also produced in other parts of China, not tainted by criminality. And there is a difficulty in trying to distinguish between tainted and untainted cotton, with additional complications because China imports cotton produced in other places such as Thailand, Vietnam, and Cambodia. And it's not clear whereabouts any tainted property, if it is tainted, enters the supply chain or through whose hands it might pass before entering the supply chain or entering the United Kingdom. Now, it was because of those difficulties that the claimants were saying, sidestep all of those problems and proceed on the basis of an assumption that everything that comes out of Xinjiang that's cotton is tainted. You should be proceeding on the basis of that assumption, because part of the argument that was being made by the claimants was that because of the background complexity and the virtual impossibility of identifying criminal property, it could nevertheless be seized, and the Proceeds of Crime Act was engaged, as was the Foreign Prison Made Goods Act, on the basis of a statistical inference which gave rise to the assumption. And the argument in relation to the Foreign Prison Made Goods Act was the same argument that was being made in relation to the Proceeds of Crime Act. I'll explain a little about that in a moment. But if I may then, with that by way of background, just go to some of the materials before I turn to the correspondence, some of the background materials, because, and for these purposes, I will be referring to some materials in the supplementary bundle. And in the first instance, I'm just going to look at some of the claimant's evidence, and then I'm going to turn to the correspondence. And in the supplementary bundle, there was a witness statement from Ms. Minogue, the consultant solicitor with Bymans. That begins at page 3. But at page 4, at paragraph 2, she's making it clear that she's gathered the publicly available evidence of a certain number of Chinese companies. And also at paragraph 4, she deals with the fact that state sources in China suggest 85% of the cotton grown in China is grown in Xinjiang. Going on to page 12, the point is being made at paragraph 20 that a company with a presence in the United Kingdom had listed a mainland facility as a supplier, not in Xinjiang, but the point being made in the footnote was you can't really trust the information that you're getting. So that's the inconsistent statements are coming out. And then you'll see also on page 12 is the reference to the company which the judge used as his as an illustrative example of the case that was being made, and it's also apparent from page 17 that at the top of the page, the company which the judge used as the illustrative example also had production bases in Vietnam, Cambodia, and Burma. I I don't know whether and in what proportions the company imports cottons from these factories or whether they operate in parallel. So this is the sort of material. And then looking at footnote 25, it appears China itself imports between 2 and 3 million tons of cotton per year. It's not possible to discover through desktop research where this cotton enters the supply chain, and then there are references to some of the materials. And then going on to page 28, if I may, just to give an indication of what's been put forward. At paragraph 58, at the end of the statement, experts on the region and on forced labour agree that it is impossible to conduct due diligence monitoring and auditing in Xinjiang at the moment, given the situation for Uyghurs, including the threat of internment, and it means that they cannot speak freely in interviews with auditors. And then also produced with this statement was some of the open source material, and we can get an idea of what was being said in the open source material at page 47. So page 47 of the bundle. This is actually a report from a publication called The Strategist, dated July 2019, which is part of the open source material. That's at page 45, and it's based on satellite imagery about the camps and coerced labour. And if I may just invite the court to the top third of the page, where the point is being made that the situation in Xinjiang is extremely opaque. An investigation of what is occurring there is difficult, but collection and analysis of open source information, including satellite imagery, provide an alternative window into what is happening on the ground. And it goes on to make the point that the Chinese Communist Party has placed strict and coercive controls on individual freedoms. So that's part of the difficulty of finding out, well, what is going on. And then at page 48, there's a reference to it's at the bottom third of the page, or the bottom quarter, which the paragraph that begins Adrian Jens, that's Dr. Adrian Jens, who's one of the leading scholars in this area, said that it will soon become impossible to determine whether products manufactured or sourced in Xinjiang are made with coerced labour. So that was the material, and we'll see what the claimants were saying as an alternative in relation to that. And also,
What was the date of that statement?
The statement from Ms. Minogue producing these was in October 2021,
And the
29th of
BBC
October.
statement was 2019, we can see that.
And the strategist was July 2019.
Yes.
And the also included was written testimony. So this was also part of the materials that have been produced. If I may invite the court's attention, please, to page 59. Page 59 of the bundle, enclosed with or included with the statement, and these were the claimant's materials, was the written testimony given by the executive director of a worker rights consortium before the United States House of Representatives on trade. And there was a discussion about the position in China. And at page 61, in the top paragraph, page 61, just over halfway through the first paragraph on that page at the top. There is, however, almost no visibility either via shipping records or brand disclosure at the level of cotton and yarns. Tens of millions of garments land every day at United States ports from factories in Bangladesh, Cambodia, Myanmar, various parts of China, and dozens of other apparel exporting countries. While many contain cotton or yarn from Xinjiang, there is in most cases nothing in the records that arrive with these shipments to distinguish those goods from garments without the tainted content. That was consistent with the evidence that had been given by Mr. Hugh, the defendant's witness, which is at page 120 of this bundle. And at page 120, there's the witness statement dated the 17th of January 22. Mr. Hugh was then the Assistant Director and Head of Customs Operational Policy in Border Force. And the effect of this, just for the court's note, it's summarised by the learned judge, Mr. Justice Dove, in his judgment at paragraphs 22 to 23. But if I may just invite the court's attention to what materials there would be at the border, because at paragraph 10, Mr. Hugh deals with the materials, and at paragraph 11, no requirement, legal or informal, for importers and exporters to identify the parties involved in manufacturing, or no requirement for importers or exporters to include details on the custom documents of the supply chain in which they've been involved, or the raw materials included which they are importing or exporting. And he goes on, it's only necessary to look at what he says at paragraph 20 at page 124, if I may, just to deal with the large volume of goods arriving in the United Kingdom against tariff codes, including cotton goods. So the running at over 1 million per month in certain months in 2020, with no reason to think that the data was unusual. And what we'll come on, I'll turn to it in a moment, but this is just a foreshadow that the claimant's argument was you should be seizing all of this because it's tainted, because you can assume it's tainted based on the statistical analysis. But we'll see how it develops. And with that, if I may, the correspondence begins in the same supplementary bundle at page 185 to begin with. And this was the beginning of correspondence which continued through into 2021. And at page 185, I'm not sure what the date of this letter is.
No, I was going to say, what is the date?
But I think, looking from the response that is at page 242, which says your recent letter, the response is the 15th of May. So it looks like it's around April, perhaps March.
22nd of April.
Oh, 22nd of April. Thank you very much. Thank you. And then, as we can see from paragraph 1, the point that was being made in paragraph 1 is there is substantial evidence that cotton products originating in Xinjiang have been produced in whole or in part with prison and or forced labour, and separately that goods produced by known prison enterprises elsewhere in China are entering the UK. And then this is what is being requested. Given these circumstances, the legal framework outlined below requires the UK authorities, notably HMRC, and then it goes on to, because there's evidence that they have been produced, suspend imports, consider seizing products already in the UK until it's established that a presumption that they are the result of prison labour is dislodged. And because there's evidence that Xinjiang cotton products have been produced with forced labour, suspend imports and can seizing products already in the UK until an evaluation is carried out. And where there is evidence that any Chinese product has been produced in whole or in part by a prison enterprise, ban further imports. And then it sets out who the authors of the letter, and then going on to page 187, because the letter is long, it's actually, I think, 56 pages. At paragraph 5, there's a helpful summary, but the point being made is it must be presumed that they've been produced. So it must be presumed that these products have been produced in whole or in part with prison and or forced labour in light of this evidence. That's the evidence about what's going on in the region. The large-scale use of forced labour must be analysed when linked to specific products entering the UK. The evidence is so compelling that our organisations anticipate willing and active consideration of these imports by HMRC. And then the letter is divided into various sections, looking at a number of companies and also the legal framework. And if I may turn, please, to page 215, because this is at page 215, there is an italicized section, which is one of the case studies set out.
Page?
215 in the first instance, if I may. 215, and I'm going to pick it up at 216. This is just to put it in context. This was a case study in relation to one of the particular companies, and then there's a reference at paragraph 48 to Dr. Adrian Zenz, who's the world-renowned expert. And then at 2.6, in the bottom paragraph, at 2.16, is this company involved in forced labour? At the very least, it's heavily implicated in a wider scheme of involuntary servitude, which constitutes a form of human trafficking. But the wider point is that traditional approaches of identifying specific instances of forced labour do not work for Xinjiang. In the vast majority of cases, such evidence will never be directly available. The ongoing intertwining of different forms of involuntary detaining and labour and the level of control the Communist Party exerts over companies renders such fact-finding missions even more futile. The only viable solution is to consider the entire region to be thoroughly tainted with different forms of coercive labour. This means that nothing made, in whole or in part, with products from Xinjiang should have any place in an ethically clean supply chain. And at paragraph 50 is the reference to the presumption, the rebuttable presumption. And paragraph 51 is, having established that presumption as a baseline, they go on to conduct an analysis on companies bringing cotton into the United Kingdom. So that is the presumption, and that is the baseline for what follows. And then if we go to page 232, please, because this is where the assumption and the baseline assumption feeds into the analysis. And page 232 is the legal framework. But just before we look at the legal framework, at 77 is the conclusion of the particular part of the letter that precedes it. It's necessary to conclude, in light of the above, there is sufficient evidence to begin identifying companies and consequently consignments of cotton, which must by law be stopped from entering the UK. So this was on the basis of the assumption. Then there's the legal framework. And when it came to the Foreign Prison Made Goods Act, the 1897 legislation, at 79, it's clear from the evidence that Xinjiang cotton products must be presumed, and HMRC is obliged to refuse to import it. And then it deals with the Proceeds of Crime Act. And that then goes on to 234, if I may just pick up 234. And the point being made here is because you could assume that there was criminal offending in China, and that was the basis on which you should proceed, you could also reach the conclusion that criminal offending was taking place in this jurisdiction, namely the proceeds of crime offences that had been identified in the letter, in particular the Section 328 arrangement offence and the Section 329 acquisition, possession and use offence. And so what is being said at 83 is these provisions, referring back to the Proceeds of Crime Act and Section 340 as well, mean that cotton goods produced are themselves criminal property, as would be any funds generated from them, including import duties. So it was being suggested that the revenue were implicated in the offending, and they were permitting others to commit offences. And the point was noted quite accurately that in the United Kingdom, proceeds from slavery has been treated as the proceeds of crime for the purposes of money laundering offence. And then there's the rationality point. So it's being put on a sort of rationality basis. There's reference to the Serious Crime Act, which disappears, we'll see. But may I just say this? That is another rather intricate piece of criminal legislation, to say the least. It raises very, very difficult issues, and what the precise interrelationship between the Serious Crime Act and the Proceeds of Crime Act has not yet been the consideration, I think, of any of the senior courts. And it may be that even the claimants thought that that was a particular bridge too far in terms of suggesting that there was some criminal activity. And then at page 236 of the bundle, the predicate offending, which is said to underlie the liability, just to sort of identify it, was the Modern Slavery Act, Section 1 of the Modern Slavery Act. It's absolutely right that if there were offending of that sort, that would be caught, and anything produced would be the proceeds of crime. And also, the point was being made that Section 1 of the International Criminal Courts Act 2001, which had incorporated effectively into English law the Rome Statute in relation to international crimes against humanity, that too might provide a basis for liability. So then the conclusion at 239 was, given the overwhelming and credible evidence concerning the scale and gravity of the forced labour regime in Xinjiang, the authorities must consider banning the import of cotton, and any failure to do so would be unlawful. And then the Foreign Prison-Made Goods Act, it's prohibited to import such goods. B, Proceeds of Crime Act, you're engaging in criminal offences and you're committing criminal offences, and the reference to the predicate offences, and then you must seek to retrieve the cotton products already present. So that was it. And may I just interpose this comment? We see here the linking of the Foreign Prison-Made Goods Act and the Proceeds of Crime Act, which we will see later in the correspondence. And the Foreign Prison-Made Goods Act became ground one before Mr. Justice Dove. And Mr. Justice Dove found that the analysis in relation to the Foreign Prison-Made Goods Act was material to the analysis under the Proceeds of Crime Act. And we'll come on to see exactly what the interrelationship was in a moment. But that was the conclusion of the letter. And then if we go to the 15th of May 2020, which is at letter 242, this is from HMRC, 15th of May 2020, and it sets out the background and what was being said in the letter, and then goes on to address various matters. But for these purposes, it's only necessary to go to 244 and paragraphs 10 and 11, because this is where the linking point comes in. This is the first occasion that we have the linking point, but the linking point is responding to an assumption point or a statistical analysis point. So here at paragraph 10, we've considered this aspect of your request, and the Foreign Prison-Made Goods Act requires there to be sufficient evidence that would clearly show to the satisfaction of the courts there's an unbroken evidential chain, specifically linking any consignment to its manufacture by prison labour. We don't consider that seizure or liability to forfeiture would be upheld where, for example, it could be shown that any exporting country or region freely manufactured the same type of goods that it might manufacture using prison labour. And within the supply chain, it was not possible to distinguish between the two. So the point that is being made is, how are we going to make the distinction between taint on the one hand and untainted on the other? And the point then is made clear by paragraph 11. Furthermore, our initial determination is that the Act does not envisage the seizing of goods on the understanding that they might be the result of prison labour, and where there is a view to investigate the matter after the goods have been seized. And there's reference to something that had been said in Parliament. But the point that was being made is the possibility that it's derived from a crime, or the prison establishment wasn't going to be sufficient. And at paragraph 13, you also ask where there is evidence that any Chinese product has been produced in part by a prison enterprise, HMRC should ban further imports of that product and consider seizing products in the UK. We've considered this aspect of your request and would reiterate that in order to justify seizure, there needs to be sufficient evidence that would clearly show to the satisfaction of the courts there is an unbroken evidential chain, specifically linking any consignment to its manufacture by prison labour. So that's looking to the end point.
But Mr. Perry, all of this is about seizure. All of this is about a case that you should seize the goods immediately because of what you know at the moment. It's nothing to do with a duty to investigate, is it?
Well, my lady, it's linked to the investigation because, as we will see, where I'm coming to, just so my lady understands the point, I don't want to take up time unnecessarily, but in the letter before claim, the Foreign Prison Made Goods Act and the Proceeds of Crime Act points were lumped together as decision 2.
Yes.
And so they're put together as decision 2 because the point that was being made is, on the basis of the assumption, you've got your crime and your prison-made goods together.
But I hope you would accept that the decision makers still had to make a distinction between them when it came to the question of whether or not there is a difference, is there not, between deciding whether to seize the goods on the basis of what you've got now and whether to carry out further investigations to see whether at the end of the investigation you're going to be any better off.
Yes, of course I accept that, but one of the points I'll be making is that's exactly what was being done, both in relation to the Foreign Prison Made Goods Act and in relation to the Proceeds of Crime Act. And we'll come on to look at this when I'm going to turn to the judge's analysis, because one of the points that engaged the court yesterday in argument was, well, where does the judge deal with all of this? And what I'm going to be saying is, first of all, he's dealing with it throughout the judgment because he's dealing with the evidential position, and it's clear, and we can see this from when we get to the end of the judgment, when he checks his conclusions against the Foreign Affairs Committee report with the assumption, and also the Corner House decision on review, which he's taking into account as relevant context, which makes it clear that it's not an initial knockout point, cart before the horse. It's actually, you've been, as he says in terms, you've been considering the end point, which any sensible investigator is going to do. Why would you put on your blindfold and say, let's take a step into investigating this, if on all the material you've got, the end point is China?
But that's the rationality point.
Well,
That's not
well,
the underlying point. I mean, we're all on the same page on that.
yes. Well, lady, I'm going to come on to deal with that, I hope. And if I may just sort of finish this exercise.
Very helpful, thank you.
Well, I'll try to do it as efficiently as I can. But page 245 at paragraph 18 is working with Border Force colleagues and the National Crime Agency to consider how allegations might be investigated. Then at 246, there's another letter to HMRC, which is the 18th of June. And one of the points being made in this letter at 247 at paragraphs 2 and 3 was the linking point in relation to the 1897 Act, and the statistical point at paragraph 3, and the point being made at 248 at paragraph 8 is at the very least, cotton produced by certain listed suppliers can be shown to constitute a person's benefit.
This letter was seen by the NCA at the time, wasn't it?
Yes. This was all this material was passed on to the NCA, and just for the court's note, at 249, there's the importer consignment identity, the Chinese supplier, and the evidence of prison labour. And the court will recall that in relation to the first supplier, that was the illustrative case used by the judge. See paragraphs 11 to 16 of the judgment, page 619 to 620. So then we go to the 7th of July, which is a letter relied upon by the appellants, but we respectfully submit that this now has to be seen in the context of this correspondence, because this is the letter of the 7th of July from HMRC, and the lawyer who authors the letter is saying, paragraph 4, it was not suggested that a percentage test would be appropriate. You'd need to carry out on a case-by-case basis.
Sorry, what page are you on?
I'm sorry, my lady, page 260.
Sorry, thank you.
260. And I'm just picking it up at paragraph 4, if I may. And the percentage test would be appropriate rather than, we're not suggesting the percentage test would be appropriate. The question of assessing evidence relating to any breach of the prohibition created by the Act is a matter for the investigating authority, the NCA. And then 5 and 6 are the paragraphs, or 6 is the paragraph that has been relied on by the appellants, but it has to be seen in the context of 5 and also what was being said earlier. You ask about the wording of the Act as it relates to goods originating in and in free circulation. We agree with your interpretation in this regard. You also ask about the application of the Proceeds of Crime Act and the Serious Crime Act 2007 in the particular context of this correspondence. You specifically refer to Section 340, that's the definition of criminal property, and you again suggest that any consignment of Xinjiang cotton is likely to contain. So it's likely. And that is a reference back to the assumption. And then what is said here, it would seem to us that the question of whether or not the property is criminal has to be conclusively determined prior to any consideration being given to the possibility of any action as envisaged by the 2002.
And you can say that there, in context, that can only mean seizure,
Yes.
not investigation at this stage.
Yes, and also, my lady, what he's rebutting there is the assumption point, the likely point. So this is all part of the point that's being made is you've got to proceed on the basis of the assumption, but that's got to be read in context. And then 262, the letter of the 3rd of August, that's just...
Just before we pass on to 262, can I just clearly understand what your submission is about paragraph 6? I see my lady seems to be ahead of me. You say action can only mean seizure. Is that right?
That's what is being said here,
Yes.
because what is being, and it's also linked.
Seize it unless it's conclusively determined that it is in fact criminal property.
Well, I think what he's saying is you can't proceed on the basis of the statistical likelihood. You've got to have something better than that, because it's linked to, you've got to read 5 and 6 together.
Yes, but there's no dispute about 5, is there? Of course it's likely. If 80 to 85% of cotton coming out of China is from Xinjiang, then it's likely, at least more likely than not, that any particular consignment is the product of forced labour. But the writer of this letter says that's not enough.
Well, my lord, there's also an anterior point as to whether actually the statistical basis would be a proper way to proceed.
Yeah.
Because if you were to go to the courts and say, well, we can't say it is, but 85% of the cotton coming out of that region, but we don't know what within that 85% is tainted.
Depends on whether the proceedings are criminal or civil, I suspect. If
Well,
they're criminal, I get your point. If they're civil, slightly more problematic.
well, my lady, what I would say in relation to that is it whether it's criminal or civil, I would suggest it's an identification problem, because if you, in criminal law terms, it's what used to be called years ago the prosecutor's fallacy, where your DNA match means that 1 in 4 million people, you are one of 20 billion or whatever who could commit this offence. And for many years, prosecutors were going to court and relying on the statistical analysis. And then it was pointed out, well, that's not...
Spiegelhalter, that's a load of rubbish.
Yes.
Because the other person could actually be the person who committed the crime.
Yes, and that's why you need to look at each individual consignment to make an evaluation based on the information available to you. And the point that was being made in the correspondence and the courts below was the statistical point, which we were saying, well, no, you can't approach it on that basis, because quite apart from anything else, on the civil side, for example, the Foreign Prison Made Goods Act, which had the civil burden, the danger was you'd at the very least, at least seizing 15% that was clean. And how do you make the assessment with the 1 million consignments coming in a month to identify the tainted? So
My point was, in fact, a much narrower one, which was, although on its face, any action as envisaged by the Acts would encompass investigation. In context, the action that was being discussed was seizure.
yes, I mean, that's the...
Chronologically, up until this, am I right? On the correspondence, nobody had said you've got a duty to investigate.
They were saying...
It's all about, at this stage, it was all about immediate seizure and immediate prohibition. That's fair, is it?
Yes, and
Insofar as they said something about a duty to investigate, it had been promised that it would be passed on to the agencies to consider that. So HMRC was simply concerned.
yes, and also the point that was being made in the initial correspondence was the Proceeds of Crime Act arose on the basis of the base assumption. So it was the base assumption.
And you see that investigation point in the very next letter. Yeah.
And we see that. I'm grateful, my lady, and so I can skip on. That's the 3rd of August letter to 263. The 263 is just further information. 23rd of November which is being provided, and it's not necessary to go into that. We can go to 270, which is also a letter of just further information being provided to the HMRC Executive Committee. And then at 279, there's the April 2021 letter, which at paragraph 2, at 279, HMRC are making the point that NCA are responsibility for investigating, and in light of all the new evidence, it seems unreasonable for the NCA to be compelled to provide a substantive response by the 12th of April. This is entirely a matter for the NCA. However, having discussed it with them, we would suggest they require until the end of June. So they were reviewing the evidence that had been provided, and at 281, just as a matter of record, the HMRC were responding to various points that had been made about the position in the United States, where there was, this is paragraphs 13, 14 and 15 of the letter, where there were withhold release orders, and the claimants had been suggesting that a similar model could be adopted here. And then 282, the author was at paragraph 20 repeating the concerns within government about goods made by forced labour. Then the 22nd of April 2021, and this also deals with the Proceeds of Crime Act and the FPMGA, and the court will see that at paragraph 2. and this is now to the NCA, the letter to the NCA. We understand the correspondence has already been sent. We needn't repeat it. Sufficient to reiterate that our organisations are extremely concerned that products produced with prison labour and forced labour are being freely imported into and allowed to circulate within the United Kingdom. The specific basis for our concerns are contravention by customs officers of Section 1 and the acquisition by importers of criminal property under 329. So and that's focusing on the 329, and then 386 is what are you doing about all of this, and various steps are set out at 286, 285 and 286. And then the NCA, the actual NCA letter, which comes just before June, it's towards the end of May 2021, sets out various formal matters at page 287.
Is this the first letter from NCA?
Yes, and this is effectively this is effectively the NCA's assessment and decision. And in relation to investigations to date, the NCA is not currently conducting an investigation, has not done so previously in this context. With previous UK investigations into transparency of supply chains, the NCA has contributed and deployed capabilities in support of other authorities who hold primacy. Then in relation to the Foreign Prison-Made Goods Act test, then the NCA agrees with HMRC that any allegation requires an unbroken evidential chain linking to prison or forced labour, and in response to the question about the standard of proof, they agree that the civil standard of proof applies to civil forfeiture, but there are criminal offences attached which may be in play, and it's for the CPS to provide prosecution advice.
Well, this is a very important paragraph under the conclusion section.
Yes, yes, and then the conclusion.
Without that, sorry, jumping ahead, we can read it, but without that intelligence or evidence, or any indication that this is available, it would be extremely difficult to prove criminality or investigate any allegation.
Yes.
Yes. And so it's looking to, it's saying doesn't have the evidence or intelligence that can be developed to directly or specifically link any final product, manufacturer, wholesaler or retailer in the UK to goods manufactured in prison or through forced labour. Without that, etc., as my lady has just said.
But it could be, just in fairness, be a point against you here, couldn't it? Because you're linking proving criminality. You're applying the same test in relation to, or the same consideration in relation to proving criminality as with the test for investigating.
But what I would respectfully submit is what is being said here is you're looking, as any investigator is going to do, you've got to look at what the practical realities are of what is it that you're looking at, and what is it that you would be investigating, and that's why the end piece of the letter is we recognise that it would be extremely difficult to prove this criminality within or at the borders to the UK. Within complex and opaque supply chains, it's often not possible to distinguish between goods freely manufactured and those with prison labour. This is classic corner house. This is for their evaluation.
Look at the logic of the last two sentences of the paragraph that I was concentrating on. Why does the lack of evidence or intelligence mean it will be extremely difficult to investigate?
Because without the intelligence leads and without information that can get you to the predicate offence, it's going to be a pointless exercise, because you have got to think, any investigator has got to say, what's my end point? What have I got to prove ultimately?
And they answer that in paragraph 2 of the letter. This is the point I made yesterday, and it leads on to paragraph 32.2 of the decision letter, that any allegation requires an unbroken evidential chain specifically linking the goods to prison or forced labour manufacture.
And that, my lord, was that was the judge's conclusion in relation to the Foreign Prison Made Goods Act, was just on that point, and it hasn't been appealed. And as we will see, that is absolutely right. And in the same,
It's that act.
well, yes.
Exactly.
We're
Not concerned with that. We're concerned with the standard that's necessary for an investigation, not with proof of seizure.
But if, well, lady, I don't want to repeat myself. The point I'm making is that the two weren't so distinct, because both involved looking at what the end result was going to be in relation to any investigation. And it's following that we get the pre-action protocol letter, which is the 16th of July, which is the next document at 290. And if I may just pick it up at 290 under the heading proposed defendants, there are 5 potential defendants, and they are they're set out, and the court will see decisions 1 and 2. We'll come on to look at what they are, and then over the page the HMRC decisions 1 and 2, NCA decisions 1 and 2, Secretary of State for International Trade decision 3, and Secretary of State for the Foreign and Commonwealth Department Development Office decision 4. And the decisions are at 292, and it can be seen that decision 1 was the seizure, decision 2 was failure to progress an investigation into potential contraventions of the Foreign Prison Made Goods Act and or the proceeds of crime act. So they're both together. And I'm going to submit that the reason they're together, and that's when we come on to look at the 10th of September letter, is that it was effectively the same identification point. Where do you get to at the end of the process? And then at 294, there's the background. It's not necessary to go into that. We've gone through the various correspondence. At 295, the background is summarised at 14. There's a substantial and credible evidence from a varied range of sources that Chinese authorities have detained, etc. And it's setting out the conduct in China. And then at 298, you can't audit these companies, and no facility has been independently verified as not using forced labour. And then the legal framework is at 301, and this is the seizure powers. And then at 304 is the Customs and Excise Management Act, and then at 305, the Foreign Prison Made Goods Act, and at 306 is the Proceeds of Crime Act, and it's making the point about at 340 underlining property is criminal property if it constitutes a person's benefit from criminal conduct. But it's not clear who it is suggested is the person who's benefited from the criminal conduct, or where and when it's taken place. And
I think you can fairly say, Mr. Perry, that there was at that stage a rationality challenge. Bottom of page 314, paragraph 47.
well, yes, and also there's a fettering of discretion at 309, and the irrationality challenge 311. 314 is decision 2. And there's the Padfield argument. And then at 314, at 46, and in the case of cotton imports, there is overwhelming evidence that at the very least there is a high risk that these are being carried out in breach of the Foreign Prison-Made Goods Act. In these circumstances, CIMA envisages that officers will use investigative discretions to investigate further, so that to decide whether a breach is made out in respect of individual consignments. 47 is making the same point on the irrationality point, because there's a high risk. And then 48 is that they want the NCA to confirm the status of any investigation. They make reference to section 378 of the Proceeds of Crime Act. That, just for the court's note, if it's helpful, that's at page 1081 of the authorities bundle, but that just deals with appropriate officers with powers in relation to specific investigations. And then 49 is irrationally failed to investigate.
No.
To justify not investigating.
Not investigating,
yes,
which is
justify not investigating, having provided with the names of specific suppliers. And then in relation to the Secretary of State for International Trade, 316, we can see that at 317, what was being said was that there should be a suspension of imports, because at 52, there's very compelling evidence that criminal property is entering the UK and being distributed for sale throughout the country. And then there's a footnote reference to section 329, and the claimants contend the authorities are obligated to open investigations and consider avenues of recovery, but it wouldn't deal with the other large volumes of criminal property entering the country on a restricted basis. And so that was the point that was being made. And then decision 4, which fell away, was the ongoing refusal to make a genocide or crimes against humanity determination. Then we come on to the 10th of September letter against that background with the various decisions, and it's made clear that there had been various actions. It then makes clear at paragraph 8 that in respect of decision 2, there's no offence of breaching the Foreign Prison-Made Goods Act, even if such a breach could be established on the evidence, of no sufficiently clear evidential basis upon which to justify an investigation into potential breaches of the prohibition at this stage. An investigation premised on potential breaches of the Proceeds of Crime Act is misconceived, and this is linking into the basis upon which it was being said that criminal property was coming in to the border. In the absence of specifically identified criminal property and criminal conduct, the Proceeds of Crime Act is of no application. But that's also the identification point by reference to the difficulties that had been made clear by the NCA in getting to the end point of the investigation. And it is perfectly true to say, and fair to say, that POCA couldn't bite, the proceeds of crime act couldn't bite if you couldn't actually, at the end point, establish the existence of criminal property. And the point that was being made in the correspondence is you can't do that, because the point that was being made by on the claimant's own case is you can't do that, because you can't say what's going on the ground in China. And then there are the background is set out, and the Foreign Prison-Made Goods Act is addressed, and CMA. Paragraph 22, 23 and 24 is the hypothetical case. And this is the point that at 22, there's no particularization of any specific consignment of goods as having been imported contrary to the Foreign Prison-Made Goods Act. There's no principal basis on which to conclude that in the absence of specific evidence, certain identifiable goods are prison-made, and that all goods labelled as emanating from Xinjiang should be presumed to be tainted and therefore liable for forfeiture, and there's no authority for such a presumption, and that's dealt with there. And then at 25, there's a reference back to the May NCA letter that they were willing to continue to assess intelligence and evidence it received where appropriate, but there was nothing that could be developed to directly or specifically link any final product manufacturer, wholesaler or retailer in the UK to goods manufactured in prison or through labour, and they were not acting unlawfully by refusing to seize. And then the failure to investigate point is also part of decision 2, as we saw in the letter before claim, where they'd put together, the claimants had put together the breach of the FPMGA and the Proceeds of Crime Act. And it's accepted that the predicate offences are capable of constituting the predicate offences are capable of being committed. However, it's a requirement of Section 340 that criminal conduct is clearly and specifically identified and the resultant property is specifically identified. That is a requirement of Section 340, and it is insufficient to deal in hypothetical scenarios or presumptions, and that's responding to the hypothesis upon which the letter had been written. In the absence of identifying a specific consignment of goods that is the product of remnant criminality, the requirements of 340 are not met, and no Proceeds of Crime Act offence can be arise. And there's a reference to the Supreme Court decision on arrangements. And then it goes on to deal with 328 and 329. It makes the point that the 329 is the more apposite offence, the acquisition. However, it says it's a defence for the person to acquire, to have possession of criminal property.
No, we've read it
Yes,
a number
yes,
of times.
okay, yes.
But what do you say about this paragraph as a matter of law?
My lady, what I say is that it is stating in uncontroversial terms, say for one matter I'll refer to, the difficulties that arise in the context of a supply chain. It's making reference to the adequate consideration defence to the extent that there's a suggestion that the defence requires the bona fide purchase for value. That's an immaterial error, I would say, because
well, A, it's not a defence, it's an exemption. And B, why is it immaterial?
well,
You accept it's an error.
well, I accept for the purposes of 3292C that does not require the person using or acquiring to be a bona fide purchaser, because you wouldn't be in the 340 definition of criminal property, given its two dimensions of conduct and state of mind. However, the reason why I say it's immaterial is if you were investigating, if you were a prosecutor looking at this material, the obvious question that would arise is how do we get from China to the UK? Because this isn't a follow the property point, the submissions that were being made yesterday. Of course you can follow the property under the Proceeds of Crime Act. This is how do you get back to the original property which has, or the original crime that's generated the original criminal property. And the difficulty in this case was that goods were in circulation that were not tainted, and how is it possible to exclude, quite apart from 3292C, the person within the supply chain who is the bona fide purchaser of a value? And so you're back to
In any investigation under the Proceeds of Crime Act, there's always the possibility, if you've got a chain of supply, of tainted goods that are being money laundered, that somebody in the middle of the chain will turn out to be wholly innocent, and therefore it will cease to be the proceeds of crime for all time and all purposes. That's a risk. But until you've investigated, you don't know whether they are.
Well, my lady, the point this is why it feeds into the rationality challenge, because the NCA assessment was we can't develop this to get the link, and that's supported by the claimant's own materials. The claimant's own materials is you can't get into China to find out what's going on, nor can you say whether a particular consignment is tainted or untainted. All you can say is that there's a risk that it is, and you'd have to proceed on the basis of some form of assumption. And so what was being said here is that the principal problem, this is also the way Mr. Justice Dove dealt with it, was the identification problem, and also, even if you could identify any property, what about 3292C? I'll come on to say just a few short submissions in relation to the statute in a moment, if I may. But the letter goes on, which makes it clear, we would respectfully submit, that the NCA was not raising some procedural evidential bar, because the specific steps taken are there set out, and I don't need to repeat what's set out there, because, and that's repeated by the judge towards the end of his judgment. And so it was making clear that there was no basis to compel any investigation, although the NCA was making clear they remain open to the possibility. And then, and also in decision 3, paragraph 35, the letter before claim proceeds on the premise that criminal property in the form of all products originating Xinjiang is entering the UK at its borders. For the reasons identified above, that premise is incorrect. Such criminal property, no such criminal property has been identified, nor do any obligations arise under the Proceeds of Crime Act. So that's effectively the end of that's the exercise I wanted to do. I'm sorry, my lady, I've taken up time, but I did want to put that into context.
Just, I'm afraid I'm not letting you go yet on this letter.
Oh, right, yes.
do you accept that on a literal reading of paragraph 31, the reason for the absence of a proper basis for a POCA investigation is set out in paragraph 32, and that reason, the first reason, is because there is no clearly and specifically identified property? Just as a matter of, there is no proper basis. The reasons for that is in paragraph 32, yes?
Yes, yes.
And the reason in 32.1 is because there is no clearly and specifically identified property.
Yes.
One of the reasons, yeah?
Yes, yes.
Yeah.
What I do invite the court to do is to read it in the context of the hypothetical scenarios or presumptions point.
And so what would have been a proper basis for a POCA investigation?
Well,
On the question of property, of identification of criminal property, what would have been a proper basis? Would there have to be any evidence of intelligence or evidence identifying specifically criminal property?
well, my lady, what I would say is that's for the experts. That's for the expert investigators. But what I would say is any investigator is going to be looking to the future to say, what is the prosecutor going to expect me to have at the end of the day? And I take the point that was put to me in argument a moment ago, which I fully accept, that sometimes there are difficult investigations and you do have to investigate supply chains. But this was a very different position because everyone was saying this is a region where you don't know, you can't know what's going on the ground. And all of the offences under the Proceeds of Crime Act are predicated on being able to establish the criminal offence.
By the rationality exercise, would there have to, as a matter of law, would there have to be any evidence of intelligence or a chain to relevant to the identification of property question in order for an investigation to take place?
Not as a matter of law. It would be the discretion of the. It's a matter for the discretion of the investigator.
Yeah.
But that's effectively, I would respectfully submit, what is being said here is this is the position by reference to the fact you can't deal in hypothetical scenarios or presumptions, and we're not going to get into a position where we can satisfy the requirements of the Proceeds of Crime Act.
Thank you.
So,
Any other questions on that?
thank you, my lady. Thank you.
Thank you, Mr.
So, my lady, what I was proposing to do then is just very briefly go to the learned judge, if I may.
Yes.
And then I'm just going to say some things about the statutory regime and one or two of the cases. So, if I may just go to the decision under challenge, which is divider 16 of the core bundle at page 614, and if I may, I'm just going to sort of pick out, or I'm going to sort of try to summarise the structure of the judgment and how the judge deals with the various arguments, because the court yesterday was focusing on the final sentence of paragraph 4, the central concern of the claimant under both the grounds 3 and 4. So 1 and 2 was FPMGA, 2 was the policy document, 3 and 4, misdirection about Power's investigation. But under both of these grounds is the defendant's view that there's a need for specific criminal property to be identified. And I'm going to suggest that the judge didn't accept that was the defendant's view, and that's apparent from the way he addresses the judgment as a whole. So in answer to the court's questions yesterday,
Yes.
where is this dealt with? We'll see it's dealt with effectively in the course of the judgment, because I respectfully submit that the judge dealt with it all very, very carefully. It was very thorough. And but paragraph 6 to 16 is the factual background.
Let me go into it. I think I understand that your submission is that you've got to read the judgment as a whole, and that if you stand back and read the judgment as a whole, the judge's very careful analysis, it is self-evident, or it can be inferred, that he didn't accept that it was the defendant's view. Is that right? Have I understood that correctly?
Exactly.
Do I take it from that you accept that there is nowhere in this judgment where he specifically answers the question in terms?
In terms, agreed.
Yeah.
But when you read it as a whole and in context, and you see the checks that he carries out at the end of the judgment, it's quite apparent what he's accepting and what he's not accepting.
I understand. Thank you.
So I'm grateful, my lady. Thank you. So 6 to 16 is the factual analysis with the focus on one of the suppliers that had been the supplier of cotton products, and 13 to 16 was where he sets out the particular evidence in relation to that material. Then the evidence underlying the claimant's case in relation to the mistreatment of Uyghur people in the production of cotton. So this would be the predicate offending. So this is the evidence of this is effectively the evidence of the predicate offending. Then paragraph 18 is the Foreign Affairs Committee, and the court will recall, and I'm not going to weary the court, I hope, by labouring it, but this is what the judge comes back to in the end, as we'll see. But the point being made by the Foreign Affairs Committee was the one that the claimants were themselves making. You can't monitor effectively, and at 48 was the assumption, and then the judge considered the correspondence, paragraph 19, and then 20, and then 22 and 23, he's dealing with the evidence from Mr. Uyghur.
Oh, no, so on the second issue, paragraph 21 of the judgment, it says that that's the 10th of September 2021, material paragraphs 31 and 32.
Yes.
And he records that for the purposes of the present application, these passages set out the resolved position of the defendant and formed the basis upon which the case was argued.
Yes, yes. And the law then is set out, and the starting point was the principles in relation to challenges. May I just sort of make a point, because the court made reference yesterday to Lord Bingham's observation in Corner House about,
Yes.
and the Supreme Court of Fiji, and what had been said in Matalulu. A point that I would make, my lady, is this. Birmingham and others, the decision of Lord Justice Laws was a decision not to investigate. And that's why Lord Justice Laws, in the quoted passage at paragraph 64, set out by Mr. Justice Dove, is the position's more open-ended, and at the end of that quoted passage, it will take a wholly exceptional case on its legal merits to justify judicial review of a discretionary decision by a director to investigate or not.
Yes.
And Corner House, of course, was a decision not to prosecute. So it wasn't an investigative decision, it was a decision not to prosecute, and it was a decision not to prosecute on public interest grounds. So there's a distinction between them, and Lord Justice Laws was saying when it comes to decisions to prosecute, that's one thing, but decisions to investigate, there's a greater degree of latitude. In the Fiji case, the distinguished members of the court in Fiji went further. In that case, they said that even with a material error of law for entering a nolle prosequi, which I know the court will be familiar with this, that it was off limits because it was within the director's discretion. It was a rather unusual case because it was the Supreme Court who told the director he'd got the law wrong because they declared it to be wrong, the Court of Appeal having previously said he'd got it right. So it was only by the operation of declaratory law that he was in error. So it was slightly unfair to the director. But even so, the court, with Justice French as one of its members, carried out a very thorough review of why in this area deference is shown to investigators and prosecutors. But in any event, the judge deals with that. Then he deals...
But you don't disagree with Sir James that paragraph 32 correctly states the law for present purposes so far as errors of law are concerned?
Yes, yes, yes. And Milady, I simply made those observations as a by the by because...
Well, you've had a chance to read the authority.
The court raised the decision yesterday.
Thank you.
And then he deals with, the learned judge deals with the seizure provisions 27, 28. Then he deals with West Berkshire. It's not necessary to go into that, and policies, paragraph. Then he comes on to the second legal theme, 31. He deals with the interpretive provision in 34 and the various offence-creating provisions, and he deals with those. And then at 35, there is reference to the decision of the House of Lords in Montilla, which, as my learned friends rightly pointed out yesterday, is authority for the principle that when you actually get into court as a prosecutor, you've got to prove that the criminal property is in fact criminal property. So from the structure of the sections, it might have appeared, actually it was under the old legislation, but under the old legislation, it might have appeared that the offence was one that was largely dependent upon a culpable state of mind. But in fact, you've got to show the property is in fact the proceeds of crime.
Indeed, yes.
And then the judge notes, Anwar, there's no problem about the types of evidence and circumstantial evidence. He notes GH and Lord Toulson's observations at 39. He deals with the civil recovery provisions, and then he comes on to the submissions and conclusions in relation to the various arguments. Now, in relation to ground one, he returns to the defendant's impugned approach. He says that the claimant says that's a misdirection in law, and he goes on to deal with that at 48, the statistical approach taken by the claimant on the basis of available circumstantial evidence does not amount to proof of the prohibition. If the statistical approach is taken and the question is analysed on the basis of an assumption that the majority of consignments are made in prison, then that approach lumps together both prohibited and untainted consignment, which does not enable the question posed by the section to be answered with integrity. Now that is the identification point, but it is also relevant to the overall analysis, because that is also relevant to the question of can you make the link when there is tainted and untainted. And also at 50, the defendant's submissions in relation to the evidential difficulties presented by the claimant's approach relate both to this ground and also 3 and 4. So there is the learned judge making it clear that the same evidential difficulties in relation to the foreign prison make also links into 3 and 4.
But not 2.
Three and 4, it doesn't go into 2 because 2 is you fettered your
Oh,
discretion.
they changed the numbers, sorry.
I'm sorry, my lady, I'm sorry.
Sorry.
I should have made that clear.
Yeah.
So 3 and 4, 3 is crime, 4 is civil.
Yes.
But the judge is making the point about the evidential difficulties. And he's saying that it's insufficient to enable conclusions as to the particular or specific circumstances of an individual consignment. And then he says at the end of 50, this is not a question of circumstantial evidence. While circumstantial evidence of the existence of a fact may be compelling, that is different from circumstantial evidence of the chance of a fact existing. That's the point I was making earlier. Yeah. The Archbishop of Canterbury may deal a perfect hand at poker, and there may be a statistical improbability about the type of hand that he's dealt, but you take into account all the circumstances to say he's not cheating. So that sort of approach, not making unwarranted assumptions, and then at 54, central to the resolution of the issues raised in ground 1.
Well, that really, we don't need that.
Yes. Then.
Do we? I mean,
well, it's only, my lady, that he does say it relates specifically to the goods that are being examined. It needs to be proved that on the balance of probabilities they were produced as part of a foreign prison. And at 56, he deals with the fact, the undoubted evidence of crime in the Xinjiang, but that doesn't satisfy the proof required under Section 1. Then he turns to ground 2, which we needn't deal with because that was the policy point. Ground 3 is picked up at 67, and the arguments are set out, and he deals with paragraph 32 of the letter and the arguments in relation to adequate consideration, and notes that the claimant takes issue with that. And at 71, 329C, the claimant submits the phrase is not clear and unambiguous in the way suggested by the defendant. It needs to be understood in context, and here the context includes other provisions. So he's taking that into account as well, international instruments, and he notes the argument the other way. Then he deals with part 5, and then at 73, he's dealing with the need to demonstrate the involvement of criminal property and requires proof that the property concerned constituted or represents a person's benefit, the importance of the required connection is reinforced.
I mean, in this section, it's all rehearsing the party submission.
Yes.
Is that right?
But he does then make the key submission that made by the defendant at 73. Then he deals with 329 as an additional point of complexity at 75. So that's, in addition to the identification point, it's an additional point of complexity. Then he deals with Hogan and then goes on to quote from what Mr. Justice Irwin had said in relation to that decision. And then at 78, the judge having carefully and accurately summarised the rival submissions, at 78, there is the reference to no realistic lines of investigation to overcome the difficulties. So the additional complexity is presented in relation to the requirement for double mens rea. That's in relation to 329. The defendant contends there is little point in commencing investigations which do not have a realistic prospect of any successful conclusion. The defendant draws attention to the inevitable need for cooperation from the PRC authorities, which will not be forthcoming, and the danger of embarking upon investigations which, in addition to being incapable of effective resolution, would carry the risk of allegations of high-handed conduct and abuse. Yeah. Then he goes on to deal with the analysis at 70.
Well, that's the starting point of the analysis. He's just finished summarising the rival submissions, including the Corner House submission at 78.
Yes, yes. And then he goes on whether there is a misdirection in law, and at 80, he analyses what will need to be established and does no more than conclude that there would be a need to prove identified criminal property, and that would be the orthodox. The defendants had taken an orthodox view, and
what does he mean by the starting point in your submission? In paragraph 80, the defendant is correct to point out that in relation to each of the offences, the starting point must be the identification of criminal property.
I'm sorry, my lady, I'm just...
So it's the fifth line of paragraph 80.
Oh, sorry, yes.
Does he mean the starting point at trial when you're proving it? The starting point for an investigation?
Well, that's where you'd have to end up, because you've got to satisfy the 340 requirements. So
you submit that, in fact, in this particular passage, what the judge is saying, or you can infer that what he's saying, is that he accepts the defendant's position about the end of the analysis, if you like.
My lady, yes, because he goes on to say...
At the end of the day.
He goes on to say, in order to prove it would be necessary. So he's saying...
Yes.
You'd have to do that, because this is what you'd have to prove, and those elements must be specifically proved in relation to specific property, because there wasn't any space or territory for assumptions. And while the claimant was entitled to draw attention to the extensive volume of material which evidences the significant concerns, etc., as the defendant points out, specific proof rather than suspicion is required to make out the offences. So he's saying that you'd have to make out these offences, and that was orthodox and accurate. And I would respectfully submit that is right. And it also leads into 81.
Well, what's the answer to the question I asked Mr. Fisher and Mr. Forster, which is what is the approach they've taken to the material? Justify the approach they've taken to the material. That approach is what the approach identified in 78 and 79. Or rather,
Yes.
78, forgive me.
Yes, which is the May letter, and also it's apparent as we will, as I've already foreshadowed, what the learned judge says about the steps which had been taken. And what's interesting about the steps that had been taken is the focus was on China, because they'd gone to the liaison officer in Beijing, because that's your starting point. It's a source point. This is even to begin your family of criminal property, however big the family may be, you've got to have the parent, and you've got to have the parent property, and then it can expand. I'm going to say something about that in a moment, but you have to be very careful about thinking that it's an expanding universe of property which has no end. But what is apparent, we would respectfully submit here, is the judge is looking at this as the end point, because he's already made clear, as he also goes on to make clear at paragraph 90, the defendant's conclusion that he little, if any, purpose served by pursuing an investigation which would not bear fruit. And
If we look at paragraph 81, trying to work out what the approach he thinks the defendant has taken is, 1, 2, 3, 4, 5, 6, 7 lines into 81, the necessary significant detail is not present. Whilst the specific offence would not be required, at least the kind of criminal activity would need to be known. The available evidence is unable to provide these requirements or provide these details. So he's looking at really what's there on the table at the time, isn't he?
But, Lady, this is also being said against the background of all the evidence that was before him, was that you're not going to get to the bottom of what's going on in China. And so, and he's also making a point about the position is going to be, if you're going to go down the route of the Proceeds of Crime Act, whether the criminal or the civil, you've got to be able to say, you may not need to know the identity of the particular criminal or the particular crime in detail, but at least you've got to say this is criminal property derived from it.
But there is no dispute about
Yes,
what's required to prove the offence. I'm
Yes.
asking you just to,
Yes.
is there any significance in the use of the present tense in terms of the approach that the defendant, he was adopting, the judge was adopting, and in terms of the error of law that is suggested was made by the defendant?
Well, my lady, I would submit not, because what he then goes on to do at 82 is, by way of useful context, consider the Foreign Affairs Committee, and they note that they're serious concerns, but they were having to proceed on the basis that you'd need to put in place an assumption, because you can't get to the bottom of it. So, at the end of 83, he says the adoption of this solution by the FAC underlines the difficulties of deploying the offences in Part 7 of the Act in this context. And then 84 is, quite apart from the relation to proof of criminal property, there are other specific problems. And he deals with 328, which is the double mens rea point. And 329, he just deals with on the basis that it's an additional complexity. I don't think anyone listening to these proceedings would think that it wasn't. The judge is saying that these are complex issues, and at 86, he's satisfied there's no misdirection. The understanding of the requirement of proof of criminal property is consistent.
That wasn't the misdirection that was alleged. What he's saying there is they understood what they'd have to prove at trial. Nobody was suggesting they didn't.
But he goes on to say that it's not a misdirection given the concerns in relation to 340, and he goes on at 87 to turn to against that backdrop to investigations, and his conclusions are similar in relation to the investigation, and then 33 is the actions, and he's also, by way of context, at 90, sorry, 87. Yes, thank you. Mr. Eady prompts me that, sorry, Sir James prompts me that it's the same problems in relation to proof that a specific consignment is properly to be regarded as meeting the definition of property in relation to the civil recovery provisions. And he then goes on 90 by way of context to deal with the absence of specificity and the little purpose point, which I've already mentioned. And the other important point of context is 91. And again, thank you for the prompt. 89 for the first sentence. The active examination, applying the principles, paragraph 32 of the same letter was not considered to give rise to a basis for further inquiry at the time, but the possibility of other information and requiring investigation was not closed off and remains open. And then 90, we've done 91 is the corner house point, because it's all ultimately about an assessment of whether there are further realistic or viable lines of inquiry. And the judge concludes that he rejects any suggestion that the NCA have applied some preconditional approach to launching an investigation. And what we say, in summary, is, first of all...
Where do you say he says that?
Well, my lady, that's apparent from what he's concluded. In summary, he concluded that the NCA had correctly looked at the end point. They'd correctly identified what they would need to be proved, and that could not be done, as the claimants had suggested, by purely generalised material. And the NCA had considered all the material to see whether there could be further investigation, and concluded there were no realistic lines of inquiry to
One of the complaints made by the appellant said that the judge misunderstood this all as a rationality challenge and failed to focus on the actual fact this is an error of law challenge. Does the second line of paragraph 93 support that submission? It would be inappropriate to leave this judgment without emphasising the limited role that the court has in relation to a challenge of this kind. I mean, when it comes to identifying whether or not there was an error of law, it's a full role. The limited role aspect is all about the margin of discretion.
Well, lady, what I would suggest is that was doing no more than not suggesting, as he goes on to say, that the case does not in any way undermine the striking consensus. So what he's not saying is this is any endorsement of what is taking place.
You can point to the sentence of 1 or 2 on the task of the court has been to determine whether the legal tools alighted upon by the claimant have been properly understood.
Yes, yes, and there's been no error in the defendant's analysis, and that's not to say that there aren't other tools. And also, he was making clear that investigations might in the future be undertaken, as the NCA had said, if the picture had changed. So
Right.
that's what we say in relation to the judgment, and we don't accept that the judge blended or introduced any deference to the NCA by reference to the approach he adopted. The judge clearly understood the distinction. The difficulty that arises in this case, and it was apparent in some of the submissions that were advanced yesterday, is that it's being suggested what the NCA should actually do, what they should actually do. All of those are matters for the NCA in the exercise of its own expertise as an investigator.
Well, I think it was accepted, in fairness, that even if the error of law for which the appellant contends were to be made out, it could well prove to be a Pyrrhic victory. I think that was realistically accepted by Mr. Fisher at one point.
Well, I think there are also submissions, my lady, about, oh, they should go off and do this, or they should go off and do that, which are...
Ultimately, what you go off and do, if this appeal were to succeed, is a matter for the NCA. And if they don't get the law wrong, then it would be very difficult to interfere.
May I just, I'm sorry I've taken quite as long as I have, but may I just sort of make some short submissions on the Proceeds of Crime Act, and also in particular 329, and this is in the authorities' materials, and section 327 is at 862. I'm not going to repeat all the submissions that have already been made, but I do want to, if I may, just make some brief submissions.
Well, let's see how we're doing for time. How long do you think you'll be on the authorities?
I think I can do this part, my lady, if the court permits, in 10 or 15 minutes.
And how long do we think, Mr. Fisher, Mr. Forster, you'd like in reply?
Lady, I would expect to be quite short.
No time pressure, I'm just asking, so we can get this.
No, given the interchange between the court and the learned friend, I can be very short.
Right. Okay, yes, Mr. Perry.
Thank you very
Authorities.
much, my lady. 327, the concealing offence, is at 862. 328, the arrangement offence, and that's the one with the double mens rea, that's at 865. And then the 329, and I just want to say something about the adequate consideration provision, because
Right.
that's at 868, and it makes it clear that a person doesn't commit the offence if he acquired or used or had possession of the property for adequate consideration. And the position in relation to subsection 3 of 329 explains what or develops the idea of adequate consideration. So if it's significantly less than the value of the property, or a person uses or has possession of it, where it's significantly less. And also C, where the provision by a person of goods or services which he knows or suspects may help another to carry out criminal conduct is not consideration. So, for example, the example that was given yesterday of the fence, the television set that's burgled, the fence is actually assisting the burglar to provide, to commit the offence, and therefore you're not going to be in the adequate consideration territory. What we would respectfully submit, because I'm conscious of the fact that there are deeper issues in relation to this, is that there has to be some caution, because on the claimant's case about the ever-expanding universe of criminal property, what about the person who buys the cotton goods on the high street in this country? Because if they are tainted property and a person buying them, suppose they read all the materials in this case and thought that there was a good chance, then the shopper is potentially at risk. And you may say, well, the shopper would be paying adequate consideration. But then the problem is that suppose the shopper then gives it to someone, that would be 327, transferring, or suppose the shopper with a group of friends decided that they were going to go out and do all of this, a 328 arrangement. So the point that was being made by Lord Justice Elias in Affalabi is you have to be very careful about looking at this. And I'm not saying for a moment that there isn't a family of criminal property that grows. Clearly it does. It's just a question of how it grows, and that hasn't been the subject of detailed consideration by the courts.
You don't need to go that far.
And you don't need to go there. And the point I was going to make to the court is Mr. Justice Dove was not seeking to write a treatise on the Proceeds of Crime Act, and I'd invite the court not to write anything in relation to this. I mean, it may be, for example, as we've conceded, that the point about bona fide purchaser is that's a valid point. But the point I'm making is, if the claimant's arguments about the ever-expanding universe are correct, then you'd follow the property into the hands of the shopper and you'd get a civil recovery order against the cotton goods against the shopper. And I'm suggesting that the Act isn't supposed to operate in that way. And also, it's not unusual for there to be breaks in the chain in this legislation.
Of course, it always assumes that your shopper has got the requisite mens rea, which is a fairly fanciful suggestion, isn't it? Unless they're particularly streetwise and savvy, deliberately go into a particular retailer who they happen to know has a nasty history.
Well, my lady, suppose they do. I mean, the question is, as a matter of principle, because if that is right, then someone reading this case and this case papers and says, right, I've now got a relevant suspicion, I'm going to buy this, I would suggest that the legislation was not intended to operate in that way. And that's why Mr. Justice Irwin, when he was deciding the case in Hogan, said, you may be committing another offence under the legislation if you do certain, but not under this legislation. That's why he was saying that, and that's why Lord Justice Elias was saying what he said in Affalabi. But you've been taken to those, and I'm not going to repeat them. All I'm saying is that there are some very big issues in relation to this, and we haven't got a defendant to make their submissions or a prosecutor to make theirs. So that's all I wanted to say in relation to that. The only final comments I wanted to make in relation to the points from argument yesterday are these a few points. First of all, we don't accept that the judgment creates any chilling effect because it was very much a judgment confined to a particular factual background. We don't accept that it would have any impact whatsoever on the sort of cases to which my learned friends made reference yesterday, in particular Mr. Talbot, about the cases which he'd put before the court where freezing orders or recovery orders had been made. And we've always accepted ANWR accurately states the law, and so far as corruption cases are concerned, this judgment has absolutely no impact on corruption cases, because a case of corruption could not ever be within, it would be argued that it could never be within the 329C exoneration of adequate consideration if you're corrupt. And so, lady, those are just the short points, and unless I can assist the court.
You've been very clear and helpful and with a clear structure. Thank you for that. Anything you'd like to know? Thank you very much
my
indeed.
lady. Thank you.
Yes, Mr. Fisher.
May it please the court, a small number of matters, if I may. May I begin by just going back over a matter yesterday? There was discussion about the polycentric nature of the decision, and a lot of discussion about paragraph 33 of the grounds of defence. If I can put it in this way so that our position is clear, we would say respectfully that you can't defend a polycentric decision on discretion grounds when you have a situation where you've exercised the discretion on a misapplication of the law, where there has been a legal error, then the decision is effectively flawed. And in this case, we've got two errors of law, which we've spelt out very clearly, I hope, in the course of our submissions. And we say that they completely floor or hold below the plimsoll line the decisions that was taken. And so that would be our submission and our response to the submissions that were made yesterday afternoon. We also wouldn't accept that this is necessarily a case where the same decision would be made if there hadn't been an error of law, or more than one, in the approach. This is not a case where we say where Section 31(2)A of the Senior Courts Act would be invoked, because it really it cannot be said that it's highly likely that the outcome of reconsideration would be substantially the same. We can't say that because, first of all, the errors of law are significant ones and important ones, and they may well lead the NCA to make a different determination. We certainly shouldn't assume for one moment that it would be the same determination that would be made. And so there's no reason to suppose we would say that the NCA wouldn't decide, properly directing itself with the proper, correct legal principles in mind, that to initiate a criminal investigation. And so that doesn't follow. And therefore, when we talk about whether this is to be described, were we to succeed in my ladyship's court, is it a Pyrrhic victory or is it not? In a sense, we would say that's a little bit of a sterile discussion because, of course, we don't know what the NCA would decide. It may well be that actually it's not a Pyrrhic victory, it may be a real victory. Certainly in terms of actually revisiting the decision, if a declaration is issued, comes from this court, that the NCA's approach is to date in considering whether there should be an investigation was seriously flawed as a matter of law, then it may very well be that of itself is more than a Pyrrhic victory. And of course, you then have to look at the broader position, as my learned friend Mr. Forster reminds me, that to make the point that in any event, you've got to look at the broader position. You can't have a situation where, in a significant case such as this, flaws in the law have been made by a respondent authority responsible for investigating, which go uncorrected. And so, and especially so, where you're dealing with a serious piece, not that all legislation is serious, but a serious piece of legislation which is in practical application every day of the week. You can't just sit there and leave it. And so therefore, we wanted to make that submission as well, picking up on what was said yesterday. So far as what we've heard today, my lady, there isn't really terribly much that I was proposing to say to the court. We've obviously listened very carefully to my learned friend's review of the correspondence, and it seems to us that when you look at the NCA letter of 10th of September 2021, and then you look at the judgment too, that really there's nothing that we can add this morning that hasn't already been said yesterday. It's absolutely clear that we would say that the letter must be read in context and is plainly, when it talks about the proof of criminal property, it's clearly referring to the position that the NCA had put before it in terms of that being established at the
What do you say to Sir James's point that it's obvious that you don't have a threshold for investigation because it's obvious that you'd be putting the cart before the horse if you proceeded on the basis that you needed to know the result of the investigation before embarking on it?
We can't simply ignore the correspondence. My learned friend's taken us to it. We read the decision, the response letter from the NCA, 10th of September 2021, and when one looks at its terms, it's plain from what it's saying that it's talking about the investigative stage. So whilst my learned friend may say and try and deflect that issue, what he can't get away from is what's actually written. And listening to my learned friend, it was very interesting because the one letter he did look at was the preceding letter to that. And in our respectful submission, that harms him and doesn't help him. It actually goes the other way. In that sense, there's nothing obvious about this. We look at what we've got in front of us. And that would be our submission that we would make in relation to the judgment as well. We can try and construe the judgment, but at the end of the day, our submission is that the judgment is come to the wrong conclusion in the two ways we've articulated. But again, there seems to be agreement between everybody that the learned judge did not answer the appellant's claims.
Well, what about the sentence that I hadn't spotted until this morning? The one in paragraph 93. The task of the court in this case, this is page 650 of the bundle, conclusion section of the judgment, about 10 lines from the bottom. The task of the court in this case has been to determine whether the legal tools alighted upon by the claimant have been properly understood by the defendant in taking the approach which they have to the claimant's evidence. The conclusion is there's been no error in the defendant's analysis.
Yes, but there has been an error.
Yeah, but we've got, it's the same thing, it's the approach which they have to the claimant's evidence, that phrase which keeps coming up.
Well, it's also tools or measures, isn't it? Because he then goes on to say there may be other tools or measures available to the executive. Well, I think that's really dealing with the ways and means of dealing with the abuses and the evidence about the abuses rather than anything else.
Yes.
But
Lady, yes.
Yes, all
reasoning
right,
is difficult.
thank you.
I mean, what do you say to the point that Mr. Perry made, that if you read this, the judgment as a whole, standing back, even though the judge doesn't specifically answer the question, it's quite clear that he has drawn the inference or accepted submissions that what the defendants were actually doing was looking to the end result and saying, well, we're never going to be able to prove it.
And we would say respectfully, it's the other way around, that the inference that comes through the judgment is that the learned judge is accepting the position that was articulated by the NCA, namely that at the time of the investigation you have to have proof of criminal property. And that's not the position. And the judge did not deal with that, and he did not, insofar as he came to conclusions of law. They were not conclusions of law that dealt with that point or dealt with the adequate consideration point. And so I'm afraid to say, with greatest respect to the learned judge, this judgment doesn't stand. That would be our respectful submission. Before I sit down, I should just cover one further point, if I may, my lady. But the one thing that Mr. Perry did say this morning that relates to the criminal offences, and in particular the adequate consideration aspect, he made the point that I think is in the papers in any event about mushrooming, and how would the innocent purchaser in Oxford Street deal with this? And the answer, I think we heard in any event from my lady, Lady Justice Andrews. You've got to posit whether or not the purchaser would have knowledge or suspicion. We would say plainly they would not, and therefore there's no criminal property issue arising.
Well, some might. I mean, some might.
Well,
As you say, as Mr. Perry says, some people might know an awful lot about this sort of thing.
well,
But anyway.
in terms of the general public, we would say that that's absolutely fanciful. And so even if there is any mushrooming, I think as it's been expressed, of criminal property, one can argue that Section 340, subsection 3, posits just that, when it starts incorporating this notion of mixed funds, where the legitimate is mixed with the illegitimate. And so we are seeing an expansion there, just within that section, of the notion of criminal property, which in many respects is quite an artificial one. And so the concern about mushrooming is not there. And the same would be the case where, for example, an assertion of adequate consideration would otherwise be made, subject to the write-outs that we've seen in 329(4). And there, where, for example, consideration is thought to be inadequate, in that situation where there's inadequate consideration, there is criminal property. We would say, in any event, as you know, our argument is that the criminal property is extant in any event for this section. If it wasn't, you wouldn't be in that section. But the short point I make is that the idea that there would be an expansion of criminal property is not something that is strange to the Proceeds of Crime Act.
Thank you very much indeed.
Thank you.
Thank you, Mr. Fisher.
I don't know if my learned friend...
Mr. Forster, anything you'd like to add?
I don't. The court plainly has the issues. I'm not going to try the court's patience by adding to anything that's been already ventilated.
May I simply add one thing, just to give the court a statutory reference, which
Yes, thank you,
hasn't
Mr.
been
Talbot.
mentioned and falls under the shopper on Oxford Street issue. So far as civil recovery is concerned under Part 5, there is a statutory financial minimum before a civil recovery action can be brought.
It's £1,000.
It's £10,000.
10,000.
Your ladyship's thinking of the bank account
I am.
provisions. That's the £1,000.
Yeah,
Your
that's
ladyship's
right.
absolutely right. But for property into which a T-shirt would come, which is obviously not property in a credit balance in a bank account, it's £10,000, and that's section 278 of the Act, and a statutory instrument unwillingly called the Proceeds of Crime Act 2002, Financial Threshold for Civil Recovery Order 2003.
Thank you. David, do you want some questions? No. Any questions, Geraldine? No. Thank you, Mr. Talbot. Well, thank you all very much indeed for an extremely interesting day and a half. Thank you for using the time efficiently, and thank you for the typically excellent submissions on all sides. Thank you very much. A large number of people involved, both in the front and second rows. So thank you for all of that. We will, of course, be reserving our judgments, and we will distribute them electronically under embargo in the normal way, inviting you to agree corrections or any necessary typographical or other amendments, and then we'll hand down in the normal way. Is there anything else?
Not from us.
No. Thank you very much indeed.
All rise, if anyone.